Welcome to a case analysis of Stone versus the Queen, 1924. This video provides all the basic facts required to understand this case. The narration will continue on to focus on the legal issues and the Supreme Court decisions. Take some time to pause and read through the basic facts. A major legal issue involved in this case is that of automatism. Automatism is a legal defense of an act that is performed unconsciously or involuntarily. It ultimately is unintentional. There are two types of automatism under the law. Non-insane automatism is an involuntary act caused by something other than a disease of the mind. Non-insane automatism results in an acquittal as the accused is not criminally responsible, nor are they a recurring risk to the public. Insane automatism is an involuntary act caused by a disease of the mind. The results of insane automatism are that of mitigated sentences that often require treatment of the disorder. This could result in an indefinite sentence as the continuation of the mental disorder poses a recurring threat to the public. In the initial trial, the trial judge found there was enough evidence laid by the defense for an argument of automatism. He ruled, based on legal precedents, that the type of automatism available to Mr. Stone was that of insane automatism. Since the Raby ruling in 1980, the law finds psychological blows are part of everyday stressors that ordinary people would not dissociate from. Therefore, in any case where psychological blows are used to justify automatism, it must be considered insane automatism. The judges also use internal cause theory and recurring danger theory as analytical tools before instructing the jury to decide the case. The internal cause theory analyzes whether an ordinary, reasonable person under the same conditions as the accused would act in a similar way. This helps determine whether the automatism was due to an internal or external cause. The recurring danger theory considers the likelihood that conditions or the behavior response would ever happen again. Ultimately, Bert Stone was found criminally responsible for the death of Donna Stone and was charged with manslaughter. He was sentenced to 7 years, including time served. The prosecution appealed the sentence, arguing it was insufficient due to the violent nature of the crime. They also posed that the accused unfairly received a double benefit from their defense of provocation, which not only reduced the charge to manslaughter, but again reduced the sentence length. The appeals court judge found that the sentence was fair, upheld the conviction, and dismissed the prosecution's appeal. Both the accused and the prosecution appealed to the Supreme Court regarding the following issues. First, whether the defense of sane automatism should have been left to the jury. Second, whether the defense psychiatric report was properly disclosed to the Crown. Third, whether the sentencing judge could consider provocation as a mitigating factor in sentencing where the same provocation had already been considered to reduce the charge to manslaughter. Finally, was the sentence fit and did it properly reflect the gravity of the offense? The Supreme Court majority found that the trial judge took proper procedure of analyzing the type of automatism and considering legal precedent set by other cases. The Supreme Court ruled that it was not an infraction of Stone's Section 11F right, which guarantees a trial by jury, as it was saved by Section 1 in this case. Their main reason for this is that jurors are ordinary men. They use their common sense, which would likely find it much too convenient that a person claims automatism after committing a crime. These cases also have so many overlapping legal and medical definitions that it's only appropriate for the judge to first analyze the nature of automatism before handing the decision to the jury. The Supreme Court found that the defense's psychiatric report was properly disclosed to the Crown. The court reasoned that the prosecution had a legal right to expert testimony, and once the defense had listed the report as evidence, it was no longer privileged information. The judge would have granted the Crown the necessary time to review the report once the testimony was heard in order to prepare for cross-examination, regardless. Therefore, disclosing the information at the beginning of the trial was not a miscarriage of justice. It had no impact on the amount of time each party had with the information. As to the issue of whether the sentencing judge should have considered provocation as a mitigating sentencing factor, when it already had been considered to reduce the charge from second-degree murder to manslaughter, the Supreme Court found it was in fact Stone's right under Section 232 of the Criminal Code to have mitigating factors be considered in both his charge and his sentence. The Supreme Court said this does not count as a double benefit, but rather it is the complete right under Section 232. There's also evidence that the judge balanced this factor against the aggravating factor of killing a spouse, referencing Doyle in other cases. Finally, the issue of whether the sentence was fit and reflected the gravity of the crime, the Supreme Court found the sentence was reasonable. The court agreed that they could not apply Section 718.2a, Section 2 of the Criminal Code because it came into effect 9 months after Stone's sentencing and cannot be retroactively applied to disadvantage the offender. They found that the provocation was rightly considered in this case as a mitigating factor and that the sentencing judge did compare this with other similar cases to best decide the sentence for Stone. Through the precedent set in Doyle, Brown, and Edwards, the judge did balance the intimate killing of a spouse against the provocation evidence. The Supreme Court noted in their deliberation that there is no one formula to determine the sentence for a case of any type of crime. Each case must be evaluated individually with their context in mind in order to reach the most just conclusion. Possible impacts of the case are vast. Here we can discuss one or two. The Supreme Court clarified through this case the process judges and jurors should take when dealing with cases involving automatism. In this case, they also noted the issue of domestic violence, particularly violence against women. While Section 718.2a, Section 2, could not be applied to this particular case, the Supreme Court judges acknowledged that Canadian society is shifting towards a gender equality era and that the law is in fact insufficient in areas, as will be reflected by older cases. They add that additions like Section 718 hopes to address these insufficiencies but cannot violate principles of justice. I think this case could be a precursor for other cases of battered men who may claim automatism or provocation in their defense. Let me know what you guys think about this case or its potential impacts in the comments below. Thank you for watching.